Quick introductions. Judge Jared Smith, and to my left, we have Judge Rachel Kamutzis, and to my right, Chief Judge Dan Traver. Counsel for Appellant, if you want to come forward and let me know how much time you want to reserve for rebuttal.
Yes, Your Honor. May I reserve 5 minutes for rebuttal?
Yes, sir. And you may introduce yourself. And just for the record, this is case 24-2294, Robert Lee King Jr. versus Mark S. Brown, MD, et al. Thank you.
Good morning, and may it please the court, Michael Davis here on behalf of the appellant of Robert King. As I said, I've reserved 5 minutes for rebuttal. Under Chapter 766, an expert who has not reviewed the pertinent medical records is statutorily foreclosed from rendering an opinion concerning the applicable standard of care. In this case, because Premier failed to produce Mr. King's medical records, Mr. King could not secure a statutorily compliant.
Can I ask you two prefatory questions? One, have you abandoned your appellate claims as it relates to the pharmacy?
Yes, Your Honor. There's no claims raised to the pharmacy. Yes, Your Honor. So there are no appellate issues with respect to that order.
The second, we issued a case called Bystrack after it happened. Are you effectively, are you going to ask us to recede from Bystrack, or are you just raising your document production claims as it relates to Premier?
So I think there's a third option. We'll ask the court to consider whether Bystrack actually applies to the argument that we raised in our case. And so I'll address that as well as we go forward to. Thank you, Your Honor. Turning to sort of the first issue, the way that I'll address this, first I'll address Premier, and then I'll also address the issue with respect to Dr. Brown, as well as Bystrack. As to Premier, the record is fairly clear. Mr. King submitted a request for his medical records to Premier. Premier never provided those records. That issue was raised in the response to the motion to dismiss. And even at the dismissal hearing, counsel for Premier conceded that that could be an issue, right? The failure to provide medical records could constitute a waiver of the corroboration requirement. And that's because under 766.204, a claimant who files a medical negligence claim is not required to do the impossible, right? Under the statute, in order for an expert to issue an opinion as to the medical negligence of the other side, what has to happen is that that expert must review the pertinent medical records. It's a statutory requirement under the statute.
But didn't Premier indicate that they had issues with getting service? Wasn't that a component of their response? And how do you overcome that?
So that relates to the issue of the notice of intent to initiate investigation. So there was an issue that was presented. This is the first motion to dismiss hearing. So there were two. So at the first motion to dismiss hearing, there was initially an issue raised in the motion to dismiss as to the sufficiency or the timing and whether they actually got the notice of intent. The response to that motion attached the proof that it had been mailed. And at the hearing, the counsel for Premier agreed with the position that was raised in the response to the motion to dismiss that the court would not necessarily even reach the question of the sufficiency of the notice in terms of the corroborating medical affidavit requirement if, in fact, Premier received the request for medical records and failed to respond to it. That's a textual analysis of 766.204. So that was the issue with respect to the first. The trial court granted the motion to dismiss, concluding that the affidavit that was attached to the notice of intent was insufficient.
But that was the first motion to dismiss, but they continued on arguing we didn't get proper service subsequently to that, correct?
Yes, Your Honor. And the court, so with respect to the sufficiency of the notice, the trial court never actually ruled on that issue. And that issue, I don't believe, is before the court. The second order of dismissal, so just sort of give the timeline. So the second order of dismissal concerned the question of whether the notice of intent was filed and was submitted within the statute of limitations. With respect to that second order, the trial court concluded that because the notice of intent was not served within the 2-year statute of limitations, that it was without discretion and that dismissal was basically automatic. Well, that was incorrect because under the Supreme Court's decision in Ingersoll v. Hoffman, the submission of the notice of intent to initiate a lawsuit is not jurisdictional. It is not a jurisdictional requirement. It is a condition precedent that is subject to waiver and estoppel. And this is the second issue that we raised in our brief. So our issue, and the issue that we believe should be reviewed as the case goes forward on remand, is did Premier waive that requirement by its both Premier and Brown? Did they waive the pre-suit notice requirements by waiting until after the statute of limitations had expired before raising the issue? The facts of this case are very much like Ingersoll. In Ingersoll, the complaint gets filed, the answer to the complaint is submitted, and after the statute of limitations had expired, the provider, the defendant, raised for the first time in the litigation that the notice was not timely submitted. And under those circumstances, the Supreme Court concluded that that was not a jurisdictional defect, that there could potentially be a question of waiver and estoppel. And here, the waiver issue in that case was the fact that the issue as to the timeliness of the notice to initiate a lawsuit, the challenge to that was raised after the statute of limitations expired. And that's precisely, yes, Your Honor.
Can you go into how and if that was adequately argued and preserved below the waiver and estoppel argument, the trial court level?
Yes, Your Honor. So this, with respect to the second issue, the answer is yes. So at the hearing itself, counsel argued that the line of case law that provided that the failure to file the notice within the statute of limitations, that case law did not apply because in this case, Premier and Dr. Brown waited until after the statute of limitations had expired. So just so the court is aware of the timeline.
How does that help you though, as it relates to the statute of repose?
Well, so the statute of repose is more of a ceiling argument. So the statute of repose argument, I don't think it's not really relevant because here the record is very clear that the injuries, right?
Could it be relevant though, in the sense that it extinguishes a cause of action? And as a legislative condition preceding to a cause of action, you have to satisfy this pre-suit filing requirement. So I think your response to that is probably yes, but waiver.
Exactly. So
okay. So, but if that's the case, then how is that argument, that second argument, preserved at all if the statute of repose is never brought up in the context of the second motion to dismiss? It's all argued about limitation.
Yeah, so I think it's both ways, right? To the extent that the trial court did not address that in its order, because remember the issue before the court is the trial court's order. What we have appealed is the court's ruling. The court ruled in its order of dismissal with prejudice that since the notice of intent was not filed within the statute of limitations, that it was without discretion. That issue was presented to the trial court. Our position on appeal is that the trial court got that wrong. Because under both Ingersoll v. Hoffman.
It also mentions, or at least gives us enough in terms of factual findings in the order. And maybe you disagree with this, but I think if you look at the face of the order, it gives us enough factual findings to be able to affirm on either limitation or repose. And again, going back to my question, it doesn't seem like your arguments relating to limitations either are relevant or were even raised in connection with repose.
Well, so that's tough, right? Because to the extent that it is before the court because it's in the order, right, then that's one of two things that would happen. That would mean that the court decided without hearing any arguments from the parties. Yeah,
we could tipsy coachman it in terms of like right rationale, like right outcome, wrong rationale. But if the court says, hey, the statute of repose is blown and I'm dismissing your case with prejudice, I think it might even be, I don't necessarily even know that that's an alternative finding. I guess what I'm trying to hone in on is if that is correct, that the statute of repose is applicable, it's blown. Then the question just becomes, was pre-suit compliance satisfied? I don't see you trying to defend that first affidavit in the briefs or below. And I don't think you could, so I appreciate the candor.
And really the reason why we do that is because under the statute, right, an expert was not authorized to issue an opinion as to the reasonableness, right, to the medical negligence issue, unless that expert reviewed the record. And
okay, so yeah, so it all goes back to that medical request, the RFP.
Yes, Your Honor.
So, and I think you said this in the very beginning of your initial brief, hey, this is the most important issue is whether or not this piece of paper at 327 on the record gets us to where we need to go. From a textual perspective, subsection 1, 766-204, what does it tell us about the necessity of what that piece of paper needed to look like?
So 766.204 does not. It does not prescribe the form of the medical records request. And Chief Judge, you're exactly correct, because the legislature has, however, and other portions of the Chapter 766 defined or described and provided for how the form of the medical authorization should be. So for example, under 766.1065, subsection 3, this is the statute governing the notice of intent to file. In that context, the legislature has provided that the medical records request that the claimant is required to provide to the other side must be in a particular form. So the court compares 766.1065 subsection 3, which does prescribe the form of the medical release, to chapter 7 to section 766.204, which does not. The court is left with the general basic principle of statutory construction that where one provision is required in one provision and it's not provided in another, the court is to assume that that is intentional.
So 766.1065 sub 3 talks about form of effectively the HIPAA release.
Exactly.
I'm wondering, because what the form of the HIPAA release says, and I recognize that y'all weren't the trial counsel and that you didn't send this, so I'm using the second person view. The form that you sent has a HIPAA release on it. It says civil litigation on it. And then in the cover sheet, you'd agree with me that there's nothing that says medical negligence. There's nothing that suggests that it's a medical negligence claim. Those words don't appear, correct?
On the cover sheet, yes, Your Honor, but on the Code of Federal Regulations disclosures, it does say that it's being used for litigation.
Civil litigation.
Civil litigation.
Could that be like a declaratory judgment action to say that I don't owe my bill?
So I think
That's civil litigation, right?
yes, sure. So I think that might be a factual question to be explored.
Awesome.
During
so if it's a factual question, did you have to ask for an evidentiary?
Well, no, Your Honor, we're at the motion to dismiss stage, and the complaint alleged, as is allowed, generally alleged, compliance with all statutory conditions.
Did the argument need to be made at the motion to dismiss stage, Your Honor? Or your Honor's ruling at this point is premature because this depends on evidence?
Well, respectfully, no, Your Honor. And for this reason, if you look at the transcript, one, the issue that's been raised on appeal, right, that it wasn't in the correct form, I don't recall that being raised before the trial court. And two, counsel actually conceded during the hearing that Premier's failure to produce the medical records could waive the requirement that the plaintiff provide a corroborated medical affidavit. Under those circumstances, the issue—
Doing a lot of work in that sense, though, right? Like, seems like it's an evidentiary determination in the sense that, like, say you had some type of a deposition or a hearing or an evidentiary showing that you could point to where you could prove that they did view it as a request for medical negligence. I think that the struggle that I'm having is that you're asking us to view that piece of paper as a matter of law, as a medical record, a medical negligence RFP. And it doesn't say those words. How would you know?
Well, yeah, so two responses. One, I think the issue is that no one can point to any part of the statute that requires or prescribes a particular form as to the medical records request. That's not in the statute anywhere.
Doesn't it say, though, copies of any medical record relevant to any litigation of a medical negligence claim or defense? So if it's relevant to a medical negligence claim or defense, do you think it'd be, I guess, more sufficient to be able to say, hey, this is in regards to my client's medical negligence claim, as opposed to just saying civil litigation, never mentioning the statute?
Well, most definitely, I would concede that, hindsight's always 20/20, and it could be that the better practice is to include that. But I ask the court to balance that against the fact that a person, as a matter of right, has a right to get one's records, right? So it's not as though the notice is needed in order to give a person the right to get their records. The argument that's being advanced is that in order for 706.204 to apply, that the person must be placed on notice that the failure to provide the medical records could result in application of 766.204. And the problem with that argument is when you go to, as we've already said, other portions of the statute where the form of the release is provided, and under 766.1065, the prescribed form of the release would say that these are necessary in order to, these are related to the pre-suit requirements. So if the legislature wanted the notice that goes out requesting medical records to include something that said the pre-suit notice was required, the legislature, whether that the records are being requested for purposes of the pre-suit requirements, the legislature would have included that here, right? The legislature knew how to include that as a requirement. And here, the legislature has chosen not to. And just under basics separations of power, although the court is correct, it could be a better practice and it could be more helpful for that to be included. That is simply not a requirement that the legislature has required. And the court should not sort of copy and paste another portion of the statute and then apply that to this particular statute here. Even more, there's not a case that has actually have said that there's no case that I saw or in the answer brief that actually said point blank that unless you include a notice that, you know, if you don't respond, that there is going to be a waiver under 766.204, then the waiver doesn't apply. Just no court has ever said that. So a claimant who is looking at chapter 766, which is very detailed, there are requirements upon requirements, a lot of things that a person has to do. If they're just going through the statute and applying all the statutory requirements, there is simply no specific statutory requirement that would apply here. And I'll note here in the notice of intent to initiate a civil lawsuit, that HIPAA form, right, that was attached, right, that request for medical records, that request was in fact in the form of the statute, was in the form of how the statute prescribes it to be. Had that same provision been applied here or if that language were in 766.204, then it would have applied as well. The court,
Counsel, you use your rebuttal if you can continue, but it's eating into your rebuttal time if you want to say.
unless the court has any further questions, I'll save my time for the rebuttal.
Thank you.
Good morning, Your Honor. Christian Trowbridge here for Dr. Brown and Premier Medical Center. May it please the court. I'm going to change the way I initially planned to start this and try to respond to one of the arguments that I heard counsel.
Okay.
Go ahead. Yep.
Oh, okay.
Thank you.
I think that before they even sent the notice of intent, they got an expert. The expert did an examination of their client. The expert got some medical records. The expert did an affidavit. And the affidavit simply did not meet the requirements of Chapter 76 in any way for what those pre-suit affidavits have to have. I think they had enough information to do a correct affidavit. They just didn't prepare the affidavit correctly. So I disagree with the argument that it was impossible to get a sufficient affidavit before they sent the notice of intent. I think they absolutely could have. I think in the overall arching picture, I think this judge followed section 766.206, which clearly states if there is an insufficient expert affidavit, then the court must dismiss the case. And the court did that twice. The court found the initial affidavit insufficient. They've agreed it was insufficient. They've agreed it was untimely under the statute of limitations and statute of repose. And the judge, for the second time, dismissed the case with prejudice, determining that this important statutory condition precedent had not been satisfied before the statute of limitations or statute of repose expired. And I believe that we timely and appropriately raised the statute of limitations and statute of repose in response in a motion to dismiss their amended complaint. And when they amend the complaint, we can amend our defenses and start new defenses and raise new arguments. Rule 1.140 allows us to raise new arguments and new defenses. I think we've absolutely timely and appropriately raised the statute of limitations, statute of repose, and the argument that they did not provide a sufficient expert affidavit before the statute of limitations, statute of repose expired. I think Ingersoll is distinguishable because that was right at trial. We didn't do this at trial. We didn't wait till trial. We did this in response to a motion to dismiss and amend the complaint. Perfectly appropriate, happens all the time.
Is the timeline for that, the complaint was filed March 2023, and then you raised it in like a month later or 2 months later? Is that a fair timeline?
Yeah, there was an agreed extension to respond to the complaint. There was a motion filed on that and an agreed order entered. So the motion to dismiss was timely filed in response to both the original complaint and in the amended complaint and the supplemental complaint. I think that one of the big problems that I try to point out in the brief, and I think you picked up on, is that they never really pushed this trial court to address any argument about 76.204. They mentioned it in response to our motions to dismiss briefly, got mentioned at the first hearing. At the second hearing, there is zero discussion at all about 766.204. And so they never acted with a lot of diligence to pursue that argument. They were fine to try to get an amended affidavit. They are the ones that offered 120 days. They could have said, give us 10 days, give us 20 days. They're the ones that selected 120 days. But they never pushed for any continuance of a hearing on the motion to dismiss to say, Your Honor, we need an evidentiary hearing. They never sought an evidentiary hearing. They never moved to strike any defenses, never moved for pre-suit sanctions.
There's no ruling on this issue at all, right?
Yeah. So I think that Your Honor, I think you all get it. Unless you have any questions for me, it's probably wise for me to just waive the rest of my time and sit down. All right, thank you.
All right, thank you. Counsel, I'm going to give you an extra minute because I had your clock rolling while he was up there introducing himself. So my apologies. This should be more than enough. So, all right, you may proceed.
Thank you. Let me start with the issue of the question of whether the issue was sufficiently preserved. Our view is this: a motion to dismiss was filed on grounds. This is the first motion to dismiss, right? So this concerns the first complaint. A motion to dismiss was filed alleging that the affidavit that was attached was insufficient because it did not include an opinion as to medical negligence. Our position on appeal is that the expert opinion cannot have included that, because in order for an expert to issue an opinion concerning negligence of a provider, they must look at the records. And because Premier did not produce those records, there's no way they could have done that. At the hearing, in the response to the motion to dismiss.
Counsel, I did want to ask you, so in 766-106, subsection 7, it says that failure to cooperate on the part of any party during the pre-suit investigation may be grounds to strike a claim, correct?
Yes, Your Honor.
So this is the idea of cooperation involved. How would they know that they were not cooperating with pre-suit investigation based on the way you drafted your, or excuse me, counsel below drafted the letter, the request letter?
Well, the request letter includes a disclosure that it's litigation, right? That it's for civil litigation. Premier only had one interaction with Mr. King, and that was the issues that are at issue in this case, right? It was the male sex enhancement procedure that he went through, as well as the medication that he received. That was the only issue. But again, I would ask the court to really apply the plain language of the statute and not add a requirement that does not exist. But going to the issue of preservation, the motion to dismiss alleged that the complaint should be dismissed because the pre-suit notice did not include a proper medical corroborating affidavit, right? A sufficient corroborating affidavit, that there's things that were missing. The response to the motion to dismiss argued that, one, we didn't have all the records. Two, and even at the hearing itself, that the opinion that we did give was based off what we had, and that as a consequence, that claim, right, that claim should be waived or dismissed. The trial court, we showed up to the hearing, and at the hearing, counsel for Premier acknowledged the argument that was raised in the response and said to the court, they've raised in their response to the motion to dismiss that we did not provide the records. And then he conceded that the failure to provide those records would waive the requirement. Counsel did not allege or claim that the evidence would show that it wasn't sent. And the court had the argument of the motion to dismiss. The court had the response plus a concession, but the trial court went with counsel's argument that the affidavit was insufficient. And we believe that implicitly overruled the objection of the issue that was raised. And that is why the issue is sufficiently preserved. The court heard argument A, heard a response to argument B, heard a concession as to argument B. The court went with argument A, which is why we believe that one, the issue was sufficiently preserved, and that it was error for the court to grant the motion to dismiss when there was no dispute that the alleged waiver to provide medical records would waive the requirement. And unless the court has any further questions, we ask the court to reverse and remand the order granting the motion to dismiss and remand for directions for an answer to the complaint to be filed, where these issues would be fleshed out if they are, in fact, an issue. Thank you.
Thank you, counsel. All right, thank you both. Court will be in recess.